message that says it's, and just hit click to got it, and you're good to go. Okay, we're going to call the docket. We haven't had this many exhibits and demonstrative aids in one case, much less two, in quite a while. We will take objections or announcements in regard to the second case, the TCB versus the U.S. Polyco case, after this case is concluded. Since Justice Johnson is recused from that case, we can't hear the arguments and stuff on anything at this time. We will do that. We're going to take a break. Judge Davis will be here, and we'll make that substitution on the bench, and then we'll take the announcements for the second case and objections. You'll get to see how that works in connection with the first case, because at the time that I get the announcements that they're ready, I need to know whether or not there are any objections to the demonstrative exhibits or anything else, preliminary matters. Please check your cell phones. Make sure they're in the off or silent position. Unfortunately, I don't think I checked mine, but so y'all know if I get a text or a call. But check your own. We do allow people to move around during oral arguments, but be respectful of who's at the lectern and the court so that we're not interrupted. I think that's it. I'll take announcements in Higgins versus Crowell.
Good morning, Scott Field here for Mr. and Mrs.
Any preliminary matters, counsel?
No, Your Honor.
Okay, thank you.
Jake Ross, Janet Bettingfield for both the Crowells and Camp Creek Water Company. Several issues relating to each one of them. So, and we have no objections to each one of the dates.
Okay. Anything? Yeah. Counsel, you may proceed when ready.
May it please the court. Good morning. This case is about a dispute between neighbors about a boat dock placed in the wrong location in a cove on a private lake. But this appeal is about statutory and procedural errors made by the trial court in the underlying case. There were three errors, actually. There was a grant of a TCPA motion. There was a grant of a summary judgment motion. And there's a grant of a motion to dismiss in the Business Organizations Code. My goal today is to give this court a roadmap and an outline to write an opinion reversing those three errors and remanding Mr. and Mrs. Higgins' claims so that they could see the trial on the merits. My intention is to begin with TCPA, then move to the summary judgment motion, followed by the motion to dismiss. But of course, I'm glad to vary that order as the court has questions and wishes. We have files of oral argument exhibits, as Chief Justice Gray mentioned, that I'll refer to as I go along. The first one is just a photo of the boat dock, so the court can have a mental picture of why we're here and what the underlying case is about. And then the other ones, 2, 3, and 4, relate to each of the three arguments. But first with the TCPA, I want to talk first about what happened in the trial court, because what happened in the trial court is improper under the TCPA. And it's rare that you have a trial court actually say what they're doing on the record to illustrate why it's an error. And so I want to it's a very brief reading, but read from page 52 of the second volume of the reporter's record. And this is the court speaking. Well, this is a unique question, and I'm not telling you that what I'm going to do is correct by any stretch of the imagination. But I'm going to grant your motion, Mr. Goss. And because I think any cause of action that may exist with Mr. and Mrs. Higgins may very well be the remedy through the board of directors of the Camp Creek Water Association, but I don't think it's the crowds. So I'm going to grant your motion to dismiss. The TCPA is a very technical statute. And I know it annoyed me when I was on the court. It annoys every judge because you get so many of these motions filed. And it's a difficult statute. It's not well written, even after the amendment. And I understand why the trial judge would want to go to the merits rather than looking at the statute itself. But that's what happened here. And if you look at the appellee's brief, it's what they've done as well. There's very little time spent on the TCPA elements. There's a lot of time spent on why the Higgins don't have a good claim. The Higgins only challenged in response to the TCPA motion, they only challenged step one. They didn't challenge prima facie case. There were no defenses raised. So we literally have it's unusual, right? We literally only have a step one case, which is, does the TCPA apply at all? And so going to the merits is error, and the trial court admitted it on the record. Secondly, the TCPA and the pre-amendment statute, which is what we're undisputedly here on, requires a communication. There was no communication pled in this case. The case law is clear. You look at what's pled. You don't look at inferences of what might have been said or what oral communications might have happened, because the trial court actually asked that question on page 17 of the record. Asked Mr. Goss, what communications are you talking about? You're talking about the application to build a boat pier. The answer was yes. And it's related to oral communications as well. So there had to be some oral communication before that. How would you do this? What would we do? And they're communicating. Well, that's inferences. There were no oral communications pled. And in fact, if you looked at where the Higgins claims based on, related to, or in response to, which is what the statute requires, communications, there are no communications. If you look at Exhibit 2, your oral argument exhibits, we put in the relevant sections of the petition, the live pleading at the time of this motion. There's no communication alleged. The
Counsel, I'm going to stop you for just a minute. Rick, could you get us 3 copies of the oral argument exhibits? I failed to bring mine. It's on my desk, but Lynette is maybe watching this on live stream. She may be printing it as we speak, but you can proceed, but we're going to try to get us 3 copies of that.
Thank you, Your Honor. The Higgins don't complain about the Crowells building a boat dock. They don't complain about them applying to build a boat dock. An owner in the Camp Creek Camp Creek Lake has the right to apply to build a boat dock. That's not a problem. And the application had no issues in it that the Higgins complained. The issue is that the Crowells were approved to build a boat dock in a certain location, and then they built it in a different location. That's what this case boils down to. This is purely conduct based. There are no communications at issue. Besides the cases in our briefs, the Dojo Bay House versus Pickford case, the 14th court's been decided since we filed a reply. I know in the local rules, I'll supply those citations after the argument. I just want to make you aware there has been. You know, TCPA is an amazing thing. After we filed our reply brief in November, there have been 36 opinions in Texas since then. So as y'all know, it's everywhere. So that issue alone ends the TCPA analysis. If there's no communications that our petition was based on or related to, this analysis ends right there. And it's a reversal and a vacation of the monetary award given to the Crowells. If you decide there is a communication that's based on, then we move on to we're still in step 1. But we look at, was the right to petition implicated? Was the right of association implicated? Was the right of free speech implicated? Right of petition has been abandoned in response to our argument. They don't claim right of petition anymore. I think that's Natural because, of course, this was an application to a private company on a private lake. Right of petition doesn't apply. But that also kind of illustrates why free speech and right of association also don't apply. Because here we have a purely private matter. You know, this TCPA jurisprudence, it was a sea change after the Creative Oil versus Lona Hills case was decided by the Supreme Court. It was a sea change because from there on, and we've illustrated this, I think, fairly well in our brief, you suddenly had courts truly looking at whether, is this a private dispute or is it truly something that's implicating, for example, safety, which is what we have the allegation of here. The Krause claim that our claim relates to safety. It doesn't relate to safety. The Camp Creek Water Association, basically kind of HOA regulation, yes, they have in there that some of their goal for the Camp Creek Water Association is to make sure that the lake is safe. Mr. Higgins, though, Mr. and Mrs. Higgins, their claim isn't based on safety. It's not implicating safety. If you look at Bus Patrol, Panton, the Woe case, and also Booster Fuels that are cited in our briefs, they all have tangential relation, perhaps, to safety. And each of those courts said, no, these claims don't actually implicate safety. The only thing is, if you looked beyond the claims, you could come up with a safety argument. And you can almost every case. Bus Patrol is a perfect example. Bus Patrol involved technology relating to school buses. And the technology was video technology that when a school bus arm comes down, the video comes on the traffic around it. And if someone decides to pass a school bus when the arm's down, they gave that to police officers. So that those people could get tickets or whatever may come to that. And also videoed on the school bus for safety reasons. But the claims underlying the case were about misappropriation of trade secrets related to that technology. And the court said, look, yes, the technology is related to safety, but these claims aren't. There's no implication of safety. The Woe case, the NGO is how it's spelled. I'm hoping I'm pronouncing that right. The Woe case, it's very similar. It's a neighborhood association. It's about things being built in the wrong place. And the same claim was made there. Well, these neighborhood rules relate to safety. Well, but the claims underlying the Woe case didn't relate to safety. And so, and you see in the PowerPoint that they gave me beforehand, they're going to point out that Mr. Higgins, when he went to the board meeting, said, well, my grandkids aren't going to be safe anymore because this boathouse is too close to mine. But his claim didn't mention that. His pleadings didn't mention that. It wasn't part of the evidence where he claimed, y'all need to move this boathouse because of my safety. This was just him in a board meeting talking about his grandkids. It's not a matter of public concern. It might have been a matter of Mr. Higgins' concerns for his grandkids, but that's not a matter of public concern. Right of association is similar in that you've seen a sea change in the jurisprudence. Now, every court that has looked at this in the last 3 years has talked about the fact that you have to have common interest in some form of public participation. The only claim made by the Krause for why right of association applies is that, well, we all pay dues to Camp Creek. We're all members of the association. Well, that's true of every homeowner association in the state. The claims don't relate to that. Again, the Higgins don't claim that the Krause didn't have a right to build a boat dock. They did. And they have a right to be a member of the association. Absolutely. The question is whether that boat dock was built in the right place. Lastly, it was a claim on the merits, or excuse me, a dismissal on the merits. And you can't have a dismissal on merits. You've got to, if we start dismissing cases on merits on TCPA, you're expanding a statute that's already overly broad, frankly. And that's what happened here. I'm going to shift to the summary judgment motion on nuisance. The allegation, and of course, this is just Camp Creek at this point because the TCPA dismissed the Higgins claims against the Krause. So all of the federal summary judgment was the Higgins claims against Camp Creek. Negligent and intentional creation of a nuisance. There's really only two cases you have to look at here, because there was a case called Cross-Tex versus Gardner out of the Supreme Court in 2016, I believe. That's really kind of the book on nuisance now. It highlights basically the history of nuisance jurisprudence in Texas and all the elements required. And of course, this court's case in Nichols versus McKinney 2 years later was, of course, binding precedent on this court. But what's interesting about, and I want to highlight a few things from Cross-Tex. Cross-Tex listed the factors that you look at in the nuisance case. It says you don't have to show all of them, but you have to have substantial interference and unreasonable interference. But the point they made is weighing those factors is almost always a fact issue. The only time you can have it decided as a matter of law is when reasonable minds can't differ or facts are undisputed. So our Exhibit 3 just points out some of the facts we have related to those factors in the record on nuisance. It also pointed out that conduct doesn't have to be unlawful or even wrong to be a nuisance. You're looking at the interference with the property. You're not looking at whether, for example, in one of those cases, you have a pipeline being built for an easement. Well, there was nothing unlawful about that pipeline being built. What was the nuisance allegation was the noise being created from it. The fact that it was lawful didn't end the nuisance claim. The question was whether the noise was too much. So here we have evidence in the record that as soon as this boat dock was built, and this is Mr. Higgins' affidavit, as soon as this boat dock was built, the Robertson County Appraisal District lowered Mr. Higgins' property value by 25%. Now, you can say, well, okay, well, what does that mean? There was no controverting evidence. There was nothing in there. His affidavit said, this boat dock caused me to lose 25% of my property value. And interestingly, in Cross-Tex, that was one of the factors they listed as creating evidence of nuisance was the loss of property value. That alone should get us past the summary judgment motion. Mr. Higgins didn't make the Robertson County Appraisal District do that. I mean, when's the last time you saw an appraisal district lower property value in Texas? It just doesn't happen.
Just something we can take judicial notice of.
It's close. No, not really, but it is something we all know, and it's something that's telling in that case. We believe this requires a remand of this claim. Now, lastly, the derivative action. Derivative action is interesting because there's really no case law on it, and it is interesting is a nice word for the statute. As I said, the TCPA was confusing. This statute to me is more confusing. You do have some guidance from the prior version of the statute, which was section 5.14 of the code back then. But there's very little case law on it too, and nothing that's really dispositive. You got two errors by the trial court in this regard. Number one, Mr. and Mrs. Higgins were not allowed discovery. What happened is the motion, there was a summary judgment pending, the summary judgment we just got through talking about. And then you had this motion filed on behalf of the corporation to dismiss the derivative suit. It was filed January 15th. A hearing was requested. The hearing was January 27th. The trial court ruled January 27th. Well, if you look at section 21.556, which we've set forth in full on the exhibit, it says if a corporation proposes to dismiss a derivative proceeding, then you get limited discovery. We moved, the Higgins moved for discovery in response to that motion. It was denied. That alone is error, and it should require abuse of discretion and reversal. The second error is burden of proof. The burden of proof shifts under 21.558 to the plaintiff if certain evidence is shown. What we have here is a pleading, a motion, and attached to that motion was a notice. And the notice said the elements, basically listed the elements of 21.558 and 21.554. It said these elements were met, signed, lawyer. It was a pleading. There's no evidence of what happened. If you look at one of the old cases, the old code was Johnson versus Jackson Walker, which will also supply you after argument for citation. It's 247 Southwest 3rd, 765. In that case, they conducted a legal and factual sufficiency review. Evidence is required. The response is, well, the court was sitting in equity. They didn't have to have evidence. I've never read a case that says that. I don't think that's the rule. Now, in equity, of course, the evidence rules are relaxed a bit, but the notice isn't evidence, it's pleading. There's no verification, there was no affidavit, there was no declaration. So the burden never shifted to the Higgins. That's an error. And so you have legally insufficient evidence for the granting of that motion. At the end of the day, what the Higgins want is a case on the merits. They want the merits of the claims heard. We respectfully request the court reverse the 3 errors committed by the trial court on TCPA, summary judgment, and the motion to dismiss the derivative proceeding. I'll reserve the rest of my time.
You'll have 5 minutes for rebuttal.
Thanks.
So, thank you, counsel.
I'm just going to hand, Judge, you asked me to bring a copy of the presentation. And one to, Mr. Field.
The main one is to make sure the clerk gets it.
Okay, well, I've got one for the clerk as well.
Okay.
Don't know that y'all do it. We'll have it up on the screen. May it please the court.
Counsel, you may proceed when ready.
Thank you. I represent the Crowls and CCWC, which is Camp Creek Water Company, and I'm going to take the actions in the order that Mr. Fields took them. I think our dispute with the Higgins is, and the dispute on the law is, this is something related to only conduct. This court is obligated to look at the TCPA definitions related to free speech, association, and even petition. Cases have said this court, it doesn't matter if somebody doesn't even plead on TCPA a petition. The court is required to read and look at all of the requirements and whether or not anything relates to the TCPA. It's a very, very liberal statute. It says that the movement, all he has to do is show by preponderance of the evidence that the claim based on, relates to, or is in response to the exercise of free speech, association, or petition. That's the first one. And in this particular case, we think it touches all three, and we'll go through that. After that, I disagree with Mr. Fields. Then the burden would shift back to the Higgins to show by a clear and specific evidence his claim for nuisance and negligence. So in the event that it touches the TCPA, then the court doesn't dismiss it if he makes a clear and specific evidentiary proceeding through affidavits under the old law that says, here's my claim for nuisance, here's my claim for negligence. And you can see there was only one affidavit that he filed at that particular time. It has none of the elements of nuisance or negligence. So if you find a TCPA, court is required to dismiss this case, as Judge Russ did. The first matter is that this is clearly, it's got to be liberally construed. That's what the statute said. That's what the legislature intended. Right of association is the first one I'll discuss. And the right of association is very general. It's the exercise of the right of association means the communication between individuals who join together to collectively express, promote, pursue, or defend common interest. And here we have a Camp Creek water company that all the homeowners are a member of. And in addition, the public uses the lake. So we have an association. Communication is very broad too. Communication includes the making or submitting of a statement or document in any form or medium, including oral, visual, written, audio, visual. So let's look at what the bylaws say. The bylaws here say that the Board of Directors shall adopt rules regulating the use of all the corporate, real, and personal property, including but not limited to the lake, roads, traversing land, and all the land in the vicinity of the lake by all persons, whomsoever. This is an association that has a specific purpose. Also it indicates in their bylaws that the rules touch on, promote, and ensure health, safety, welfare of the owners of the stock and of the general public. And here's the rules and regulations requiring anybody that wants to build a boat dock to make application to and submit a building permit. And that's exactly what the Crowds did. This doesn't have anything to do, if this was conduct only, and we'll see, and what Mr. Fields is saying is correct, then there is no case here, because this is not, well, you got approved and that's okay. We don't care if you got approved, but you built it in the wrong place. Okay, that's what that's what he's saying. And here is the building permit, and you can't read that, but that's Charlie Crowd's building permit. Here is the portion of the building permit, which is Clerk's Record 363, and you'll see this little, they just draw this little area. There's no meets and bounds description. There's no, that's all that's required is, this is where I'm going to build it generally. And then this is where it's built. So could you go back to press P? So once again, this is where he said he was going to build it. This is the application. And this is where he built it. Now, what happened then was Mr. Higgins complained about it, and it went back to the board. And this is on the record 244. They actually had a discussion about this, and they approved it. So they approved the new location. So this is not.
Is approval the right term, or is it ratified since it was already built?
Yeah, they ratified the building permit. You see what the drawing was. The drawing wasn't really, I mean, it was just an area of where, okay, this is where it is. They didn't say, I'm going to build it in this 10-foot square. They just said, this is generally where I'm going to build it. And the reason that they gave, if you read the record, is because we wanted to get to some deep water. And the association said, yes, you can do that.
Well, what effect is it if the lady on the board, when she sees it, says it's in the wrong place?
Well, there's no effect on that now because they ratified it. So there was an application and they ratified that, but that's really not what the case is about, according to the Higgins. The case is saying, okay, I didn't petition for the fact that it was just, I mean, I petitioned for the fact that it was just in the wrong place. I didn't petition because of anything else. And that's is not right. And I can get to.
But my understanding of their lawsuit is that their complaint is not that your client petitioned Clear Creek. It was that it is built in a place other than where it was approved.
Okay.
And so I am looking for that petitioning conduct as opposed to the construction conduct.
Okay, can you go to slide 19? Okay, here is what the petition says. And the petition says that they built it in violation of CCWC's restrictions against any boat dock that extends from the shoreline more than a third of the distance across the cove and encroaches on property lines. Okay, the difference of the 10 feet that they moved it doesn't change this allegation or petition. It also says it's drastically close to the existing boat dock. Well, there was no, it was approved, as you saw, where that little drawing was, but that little drawing didn't have anything to do with this is a specific meets and bounds description. They also say the new boat dock not only provided danger, but nearly completely blocks the water access of lot 340. So what they're upset is, they're upset that that the Crowes built a boat dock in front of their lot 340. And they don't have any right to be upset about that because they have absolutely no ownership in the lake. They have absolutely no right to build any boat dock at all. They don't have an absolute right to build a boat dock. The only thing they have is to ask for a license. So the pleadings here are related to, and in fact, if can you go to 57? Here's the paragraph above the paragraph that I was reading. It said the Crowes wanted to build a boathouse, but the water directly in front of their lot was undesirable to the Crowes. To remedy this situation, on October 25th, the Crowes submitted an application to CCWC for the construction of a boat dock directly perpendicular to the Higgins existing boathouse. Okay, so that is the pleadings related to association and related to free speech, because they're pleading that the only way they could build a boat dock is to make this application. They made the application, it was approved, it was ratified, and so the Higgins now are upset because there's a boathouse right in front of their property that they don't like. But it all relates to they had to plead it because the Crowes had to, under the rules of the association, they had to ask for the application. They have said, they have pled, they asked for the application. They have pled, as we saw in the previous slide, that this was in violation of the rules and regulations related to it. They didn't say where it ended up. They said they applied for it and it was in violation because they shouldn't have even granted it in the first place. And that's what the Higgins are upset about. You go to 16. So it clearly meets the definition of association. If you read, if you look at under any textual basis, if you look at that, it meets the definition of association. The right to free speech, the court says, or the statute says, it's got to be a matter of public concern. And so in order to be a matter of public concern, you have to look to see, okay, was it a matter of public concern? Here, the Adams versus Starside case says the TCPA creates a wide net. It casts a wide net. In fact, this court in Leader has said the same thing about that. Almost every imaginable form of communication in any medium is covered. Okay, that includes the application that the Crowes made. Higgins then made a petition, which is exactly the definition of the TCPA. The matter of public concern includes, but is not limited to, environmental, economic, and other factors. And here I've just had the slide again about this relates to health and safety, because that's what the Camp Creek Water Company is relating to. And here they have said it has provided a danger. It almost completely blocks the water. It was ratified. Here is the counsel for Higgins says in this particular letter that the significant safety risk to shareholders and the general public, and it's a violation of CCWC's building regulations. Okay, so there he's talking about, it's not talking about it's a violation of the fact that you approved it and then they moved it. That's not what he's talking about. He's talking about this is a violation of their building regulations. This is a safety matter. This fits right into the definition of the freedom of speech. One stated reason for the regulation on distance is safety. And the directors ignored the safety regulation, not when Crowell moved it 10 feet, but when they approved it, when they applied for it, and when they approved it. And here is, this is the May 12th, this is May 12, 2018. And in, the petition wasn't filed until 2019. So it was already approved, and Higgins goes to the meeting, and Higgins says, this is concerns a safety concern. And he says, I would like for the boat slip to be moved to the other side. That's what he says in that meeting, which is there in the clerk's record. So we're still talking about the application of Crowell. He's mad about the fact that he thinks that it was the application was not according to the rules. He's pled that, and that comes under the TCPA. Later on in his affidavit, he says that the location where the Crowell boat dock was actually built is a violation of the published rules and regulations and is a safety hazard. So once again, he is talking about safety. This court in Florida, metal products, it said all it has to do is tangentially relate to health and safety. And they looked at the Creative Oil and Gas case. This court looked at the Creative Oil and Gas case and said, look, this is a matter of public concern. And the matter of public concern was a workers' compensation issue. There was a workers' compensation claim, and there was a defamation claim. And this court said that's a matter of public concern, relates to free speech, and it's a matter of public concern. So this clearly is a matter of public concern. We also believe that I'm going to just run through the right of petition, because if you look at the definitions, the official it's a exercise of right of petition means an official proceeding. An official proceeding is conducted in front of a public servant, and a public servant is defined as somebody who is sitting in making decisions, and it can even be a private written agreement. That is 27.019. So we think that it touches all three of the association, free speech. It's not limited to government. Youngkin versus Hines case, the Seminole case on that, and the Long Canyon Phase 2 and 3 Homeowners Association case indicates that homeowners associations can be subject to the TCPA. Doesn't have to be government. It can be homeowners associations like the CCWC. So we believe that the TCPA stands, that you should affirm Judge Russ on the TCPA claim. Now, the motion for summary judgment, Higgins doesn't have any, the CCWC doesn't have any duty to Higgins. Higgins has not shown any duty that CCWC has. This is a lake. He doesn't have any ownership of the lake. the CCWC's property goes beyond what the lake even has. They have a 30-foot easement. He doesn't have any right to be out on that lake. There is no odor, there is no smell, there is no noise, there is nothing that would be a nuisance other than it's sitting there and it's in his view. And the case that we've indicated in the brief is the Charlotte versus Gulf Oil Company, which says a building or structure cannot be complained of as a nuisance merely because it obstructs the view of a neighboring property. There is no allegation that we have done anything on lot 340. We haven't touched it. We haven't done anything at all. It would be like somebody having land that they say, you know what, if you ask me, I'll give you a license to go through my property, but it's revocable, which this license is revocable for anybody. And so somebody then sues them and says, well, he wouldn't give me a license to go through the property. First of all, Higgins has never applied for that. He's never been denied a boathouse. He just says that he can't build one, but he's never been denied a boathouse. We've never told him that he can't build a boathouse, CCWC. And there is nothing that we've done that is in violation of any rule or regulation or of any law. And so there's nothing that we've done that has indicated that 340 is any different. Now, you know, he says, well, there's no causal connection between a loss of 25% and the building of the Crowell boathouse on lot 340. So we don't know what he did, but there is no causal connection there. So he has not provided any evidence to indicate that that he is entitled to any right to any boathouse. And there is no evidence of any nuisance, no smell, no noise, no nothing other than the boathouse is out there. So I see that the time is up. I'll answer any questions, but he just doesn't have, CCWC doesn't have a duty to Higgins. Higgins does not have a right on anything other than to ask for a revocable license. And so it could not create a nuisance, and CCWC was not active.
Thank you, Council.
Thank you.
You may proceed when ready.
Thank you, Your Honor. I want to take each of the points Mr. Goss argued. First of all, the only communication we heard about was the application for a boat dock. You look at our pleadings, you're not going to see any complaint about an application for a boat dock. Every member of Camp Creek Association has the right to apply for a boat dock. That's not the basis of our claim. TCPA ends right there. Number two, claim is you shift the burden to the Higgins to show a prima facie case. That's true if the defendant had shown that TCPA applies. We never got there. We shouldn't get there. That's not something we're even arguing in this case. Number three, on right of association, it's key to remember that TCPA claim is only on the Crowell's claim. It's not on Camp Creek. Camp Creek, I haven't evaluated it, but they might have had a decent TCPA motion had they made it. They didn't make it. This is about the Crowells. The Higgins claim is the Crowells only. So the question is, what association do we have there? The Crowells are husband and wife. That's not enough. They're members of the association. Yes, so is everyone on the lake. There is no claim made by the Higgins that bears on their right to associate with Camp Creek. The question is, did they build a boat dock in the wrong place? That's it. That's the only thing. The slide they showed, number 18, was about Camp Creek. It was a background allegation because if you recall, the petition relates to both the Crowells and Camp Creek. So for the TCPA motion, it's just the allegations about the Crowells. And if you look at our exhibit number 1, those are the only claims we made against the Crowells. That's it. There were no allegations of communication. There were no allegations about association. They put on the screen a letter from Bill Youngkin, CR 234. Look at that, please. That's a letter about the derivative claim. It's not in the TCPA record. Look at that, please. That has nothing to do with the arguments we're making. Mr. Youngkin on a derivative claim, he can talk all about the rules and regulations, which is what he did. Look at the TCPA record. They don't want you to because the TCPA doesn't apply. But Higgins didn't plead what he said at the board meeting. And all he said at the board meeting is, I'm worried about my grandkids. That's not a matter of public safety. If bus patrol, if the TCPA doesn't apply there, it sure doesn't apply here. The Creeder case, I represented Flamco in that case. I know that case very well, and I did argue that the right of free speech applied. And the reason I argued it applied is the petition by Mr. Creeder specifically said they wrongfully terminated me because of the reasons they stated in a letter that I got, which was a communication where all the affidavits in the record on the TCPA motion by every member of Flamco said, we fired him because what he was doing impacted the safety of every worker in this plant, and there were hundreds of workers, and someone's going to get hurt. That's why this court applied the TCPA. Excuse me, applied the TCPA in that case. It was the record. Record had plenty of communications in there. I know we didn't convince Chief Justice Bray, but we convinced his counterparts that we were right on that. This case isn't anything like Creeder. It doesn't have the record that Creeder did. Right of petition is the first time I've heard it. But if you look at the right of petition statute, it requires, we address it in our opening brief, and it's talking about the definition. I'll just read it to you. It's covers a detailed list of communications made in pertaining to judicial, official, legislative, or governmental proceedings, or that are likely to encourage public participation or participation or review by a governmental body. We don't have that. There's no right of petition. And on the summary judgment, there is a duty. We shift to Camp Creek. There's a duty. Because remember, we're not on Camp Creek. We are talking about safety. We're talking about application of the rules and regulations to everyone equally. And you're right, Justice Smith. They said on the record, we let them build a boat dock around place. And one of the board members actually said, how are we going to ever apply our rules when we don't apply them equally? There is a duty there. I see my time's up. We respectfully request that the court reverse the judgment of the Court of Appeals and remand for trial. Thank you.
Since it's the judgment of the Court of Appeals that you'll be getting, isn't it the judgment of the trial court you want us to reverse?
Did I just misspeak? I'm sorry. I'm so sorry.
That's all right. We know what you want.
Old habits. Thank you.
Understood. This case is submitted and y'all are excused. Thank you. And at this time, the court will stand in a brief recess so that we can change the panelists.